Hi, I'm Dave Ertl, Senior Employment Lawyer and founder of Ertl Lawyers. If your employer has made changes to your employment or continued employment has become intolerable, it might be a constructive dismissal. In this video, I'm going to talk about how to recognize constructive dismissal and what options might be available to you. Here we go. There are two basic categories of constructive dismissal, and the first category is where the employer makes a fundamental change to a term of your employment without your consent. The most common fundamental changes that trigger constructive dismissals are a demotion. Well, a demotion is more likely to be considered a constructive dismissal where it results in a loss of prestige and status, a loss of perceived and actual leadership, or a loss of advancement. Another is a layoff. A layoff, unless expressly permitted by your written employment contract, is almost always considered a constructive dismissal. Another example is a reduction in compensation. Generally speaking, anything more than a 5 to 10% reduction in your overall compensation is a constructive dismissal. Those are the top three, but other examples include a change to your reporting relationships, a change in your job duties, purposely reducing your effectiveness, additional work with no compensation, an increase in your working hours, and a reduction in your managerial responsibilities. The second category of constructive dismissal is based around the employer's conduct that makes your continued employment intolerable. Such conduct might include abusive and inappropriate behavior of the employer, a demand for your resignation, harassment by a coworker, unwarranted negative performance reviews and PIPs, unwarranted discipline, a breach of your privacy, and a destruction of trust. What are your options if you've been constructively dismissed? Your options depend on your particular set of circumstances, of course, but in general, someone who's been constructively dismissed has a number of options that might include the following. Number one, accept the change. Now, this makes no sense if the constructive dismissal is based on harassment or abuse, but it might make sense if the constructive dismissal is based on a change in your job duties. Option two, advise the employer that you're willing to try out the change without giving up your right to claim constructive dismissal. Now, how long can you try out the change for? The law says for a reasonable period of time. That period is generally considered longer for longer-serving employees. Option three, reject the change and ask the employer to not implement the change or undo the change if it's already been made. Option four, claim constructive dismissal and continue to work for the employer only to mitigate your damages. Option 5. Claim constructive dismissal, don't return to work, and then seek compensation. As you can see, constructive dismissal can be a very complicated matter, and you should always consult an experienced employment lawyer before you take any steps. Every option has consequences, and your lawyer will be able to advise you on the most appropriate strategy. Once again, Dave Ertl, Senior Employment Lawyer at Ertl Lawyers. If you believe you have a case for constructive dismissal or you're unsure, call us today. We offer a free consultation. We'll help you understand your rights and entitlements. Our help can make all the difference.